Today's video is brought to you by Cleary and Co. Solicitors. The topic of today's video is bullying at the workplace. Employees and employers have a legal contractual relationship, and evidently it should be a professionally based relationship, and any bullying in a workplace is unacceptable. Now, it can be common and people accept it more than they should, but this video should give you a baseline level of knowledge on the matter. Employers have health and safety legal obligations regarding their employees. If you are being bullied at work, we will be happy to help you with any questions you may have. Bullying at the workplace definition. Bullying at the workplace is repeated inappropriate behaviour that undermines your right to dignity at work. It can be done by one or more persons, and it is aimed at an individual or a group to make them feel inferior to other people. Bullying can be verbal bullying, physical bullying, or cyberbullying, which is carried out on the internet or mobile phones, through social networking sites, email and text. It can take many different forms, such as social exclusion and isolation, damaging someone's reputation by gossip or rumours, aggressive or obscene language, repeated requests with impossible tasks or targets. In 2005, the Expert Advisory Group on Workplace Bullying reported that bullying is an increasing problem in the workplace. A survey on bullying was carried out as recommended by the group, and Bullying in the Workplace Survey Report 2007 was published. In many European countries, the term mobbing is used instead of bullying to describe the type of hostile behaviour in the workplace. Employment equality. The Employment Equality Act places an obligation on all employers in Ireland to prevent discrimination and harassment in the workplace. Bullying, which is not linked to one of the discriminatory grounds in the Equality Act, is not covered by the Employment Equality Acts. The Code of Practice on Sexual Harassment and Harassment at Work aims to give practical guidance to employers and employees on how to prevent sexual harassment and harassment at work, and how to put procedures in place to deal with it. Health and safety at work. Bullying in the workplace can affect both the safety and the health of the employees. Under the Safety, Health and Welfare at Work Act 2005, employers have a duty to ensure the health and safety of their employees in the workplace. The Health and Safety Authority works to ensure that workplace bullying is not tolerated and that employers have procedures for dealing with bullying at work. It provides information and advice on bullying and is responsible for the code of practice for employers and employees on the prevention and resolution of bullying at work. This code sets out guidance notes for employers, employees and trade unions on dealing with bullying in the workplace. Your employer must take reasonable steps to prevent bullying in the workplace. There should be an anti-bullying policy and established procedures for dealing with complaints of bullying in the workplace. Your employer should deal with such complaints immediately. The Labour Relations Commission has published a code of practice detailing procedures for addressing bullying in the workplace. How to apply. You should begin by making it very clear to the person concerned that you find his or her behaviour unacceptable and undermining. If this informal approach is not enough to resolve this issue, and in situations where the bullying continues, you may need to consider making a formal complaint. You should report the bullying to a manager. Your employer's policy on bullying should clearly set out what will happen when a formal complaint is made, how the complaint will be investigated, and who will carry out the investigation, taking into account issues of confidentiality and the rights of both parties. If you feel that your complaint about bullying has not been dealt with properly by your employer, one of the following options may also be available to you. Employment equality. If you are being bullied in relation to one of the 9 grounds for discrimination, you can bring your case to the Equality Tribunal. You can make a complaint under the Employment Equality Acts. Health and safety. If your workplace does not have an adequate bullying policy, you can make a formal complaint about this to the Workplace Contact Unit of the Health and Safety Authority. Unfair dismissal. If the bullying becomes unbearable and you're forced to leave your job, you may be entitled to claim constructive dismissal under the Unfair Dismissal Acts. This means that although you left your job voluntarily, in reality, you were forced to do so because of the way you were being treated. Time limits. Complaints under the Employment Equality Act and the Safety, Health and Welfare at Work Act must be brought within 6 months of the contravention of the legislation to which the complaint relates. This time limit can be increased to 12 months if a reasonable cause for the delay can be shown. Disclaimer. Please be advised that the mentioned material in this video is intended as an overview and as a broad outline of the topic discussed. It should not be considered as complete and comprehensive legal advice, nor act as an appropriate substitute. Due care has been taken in the publication of this video, and we do not accept legal liability as a result of reliance on any material covered in this video. Brought to you by Cleary and Co. Solicitors.